In this video, I'm going to explain how the grievance procedure works in South Africa according to the Labour Relations Act of 1995. Please note that I am a teacher by profession and the information provided here is purely for informational and educational purposes. Also, whenever you hear me use the acronym LRA, just know that I'm referring to the Labour Relations Act. Why is it important to understand the grievance procedure? Well, interpersonal issues are common in the workplace, and when they do occur and aren't easily resolved, it is important to know the correct steps to follow. Some people assume that if they face unfair treatment at work, they can go straight to the CEO, director, or even the CCMA, and that is usually not the case. In most situations, you need to start with the person directly responsible for you, whether that is your supervisor, site manager, HOD, foreman, or whatever title your workplace uses. Before escalating a matter to the CCMA, there usually needs to be evidence that you did try to resolve the issue internally first, but did not succeed. Knowing this gives you a clear understanding of what to do, and saves you the frustration of being sent back to the person you should have approached in the first place. For business owners, following the correct procedure can help you reduce legal risks and costs by resolving issues internally before they escalate to the CCMA or Labour Court. What is the correct procedure for dealing with grievances? For this section, I'll be using the 2024 Revised Business Studies notes by the South African Department of Basic Education from the topic Team Performance and Conflict Management. An aggrieved employee must verbally report the incident or grievance to his or her supervisor or manager. This is your immediate supervisor, the person you report directly to. If your issue is with the supervisor, then you would have to report them to the person they report to or directly to HR. But to keep things simple, we're going to base this procedure on the assumption that the issue is not with your immediate supervisor, but someone else. Before escalating the matter to a higher authority, you must first attempt to solve it at this level. Speak to your supervisor and give them time to try and resolve it. The supervisor or manager needs to resolve the issue within 3 to 5 working days. According to the Labour Relations Act, there is no specific time frame for resolving a verbal grievance. The only requirement is for it to be handled promptly, meaning as quickly as possible. The 3 to 5 working days are not compulsory under the LRA, so you can take it as a suggested time frame to work within. Should the employee and supervisor not be able to resolve the grievance, the employee may take it to the next level of management. The next level of management is not necessarily top management. It is simply the person who your manager or supervisor reports to. The employee may move to a more formal process where the grievance must be lodged in writing or completes a grievance form. This means that the grievance could still be verbal, unless you, as the aggrieved employee, choose to formalize it by filling a grievance form. The employee must receive a written reply in response to the written grievance. Once you formalize the complaint in writing, although it is not specifically required by the law, it is best practice for the employer to then also respond in writing. A grievance hearing or meeting must be held with all relevant parties present. This is everyone involved in the grievance, as well as those who are overseeing the process. Minutes of the meeting must be recorded, and any resolution passed must be recorded in the formal grievance form. Since it is now a formal meeting, minutes must be recorded and the outcomes documented in the grievance form. This provides written evidence of the intervention. Should the employee not be satisfied, then he or she could refer the matter to the highest level of management. This now refers to top management, such as the CEO, director, or the owner of the company. However, it depends on the size of the company. In a large national corporation, the highest internal level could just be the designated HR manager. But If you do have access to top management, this is the stage where you would raise the grievance with them. After approaching your manager and their manager, and they both have failed to resolve the issue to your satisfaction, top management should arrange a meeting with all relevant parties concerned. Minutes of this meeting should be filed or recorded, and the outcome or decision must be recorded on the formal grievance form. Again, keeping a written record is required since the grievance is now formal. Should the employee still not be satisfied, he or she may refer the matter to the CCMA, who will make a ruling on the matter. At this point, the issue is no longer a grievance but a dispute, and the CCMA may issue a ruling if necessary. CCMA stands for Commission for Conciliation, Mediation, and Arbitration. Conciliation is when a neutral person, the conciliator, helps two parties to talk through their issue and try to reach an agreement. Mediation is when the neutral person, the mediator, gets more involved by suggesting ways to solve the problem. Arbitration is when the neutral person, the arbitrator, listens to both sides and then makes a ruling that both must accept. At the CCMA, a dispute usually goes through conciliation first, and if not resolved, it can proceed to arbitration. Mediation can be offered, but it is not compulsory. The matter can be referred to the Labor Court, Labor Appeal Court, or Constitutional Court on appeal if the employee is not satisfied with the outcome taken by the lower courts. Ideally, the dispute should be settled at the CCMA level. However, if you are unhappy with the CCMA's arbitration award, you can take the matter on review to the Labor Court. If you're still not satisfied with the Labor Court's decision, you can appeal to the Labor Appeal Court. If you're still not satisfied after that, and if constitutional rights such as equality, dignity, and fair labor practices are involved, you can take the matter to the Constitutional Court. However, not every labor dispute automatically qualifies for that. With that said, the Constitutional Court is the highest level that a grievance can be contested at locally. Here's an extract from the Labour Guide website which gives further clarity on when the grievance procedure does and doesn't apply. It must be noted that the grievance procedure may not be used to address unfair labor practices, salary or wage issues, demands for other benefits, or as an appeal mechanism following a disciplinary hearing. That is because the listed issues are considered disputes and not grievances. If a business has started a disciplinary procedure against you and you believe that it is unfair, you can't use the grievance procedure to challenge it. You usually have to wait for the disciplinary process to end, and then you can go to the CCMA to dispute it. The grievance procedure is the vehicle used by an employee when he has a grievance or complaint related to his working conditions. This may be that his supervisor is continually picking on him, or his workstation may be situated in a drafty area which gives him a health problem, or perhaps there is some conflict between the employee and the fellow worker, and so on. As you can see from the examples given, the grievance procedure is used when an employee has a problem with how they are treated at work, and not for challenging disciplinary action, salary disputes, or other legal matters. And now that you understand the grievance procedure, you might want to learn about the purpose of the Labor Relations Act and its relationship with the CCMA and labor courts. Stay tuned for that video, or click on the icon on the screen if it has already been published. This is B.Studies, and I'm Miss Shabalala. Take care.